my name is Natalia Willette, and I am a real estate attorney here in the state of Florida from the firm LCO Law. And if you have any questions, you want to reclaim your time and your sanity when it comes to possession and marketability issues involving your real estate investments, call us at 813-480-2106. So today I wanted to discuss what happens and what do you do as a landlord when a tenant leaves and they leave behind what seems like personal property. And what do you do if some of that looks like trash, but maybe potentially it looks like personal items left behind? So I wanted to address this because there's actually two circumstances that come into play when a tenant is no longer in the property and they've left things behind. So number one, if a tenant vacates the property because you've gotten a writ of possession and the sheriff is there and the sheriff has to forcibly remove them and they've left items behind, then you do not have any obligation to keep or maintain those assets for them. They pretty much have got to go, and you're allowed to take all that crap, throw it away, clear out your property, and move on with your life per se when it comes to that. That is a little bit different from when your tenants voluntarily vacate the premises. So that's either because they decided to leave early prior to the expiration of their lease, or their lease did terminate and they've left on the date that it ended, but they've left some things behind. Or even if you are like already in the middle of eviction proceedings and they decide to voluntarily leave before a sheriff comes by and executes the writ of possession. And those get treated differently than when a person is forcibly removed through the sheriff's process of executing a writ of possession. So in those cases, there's a different Florida statute that gets triggered. And what this says in essence is that you are allowed to go in and of course clean up and move the items, but you have to provide notice to your former tenant if it looks like they left something that's actually like personal items, not just trash, but like personal items. You have to provide them with a notice, a written notice, that here's what's left behind, here's a description of what's left behind. Please come pick it up within 10 days of receipt of this letter. If it's in person, it's 10 days. If it's mailed, then it's usually 15 days that they have in which they can pick up their items pursuant to the notice that you gave them. And that's done, of course, with the idea that people that voluntarily leave may have inadvertently forgotten some items, or they may have not been completely done removing their things, and that gets treated differently from people forcibly removed. In those cases, there's a couple of things. If what they left behind appears to be worth less than $500, then you actually are free to dispose of it or sell it or throw it away. If what they left behind is an estimated value more than $500, then you generally do have to store it somewhere and put in the notice that you're not responsible for what happens during storage, and you are allowed to collect for the storage costs for keeping their things during that period of time. So those are the differences. That's something you should know. And if you need help preparing those letters in the event that your tenants vacated but they weren't forcibly removed and you're not quite sure about the value of the property, so you want to be safe, in that case, you can give us a call, 813-480-2106. We'd be happy to help you. That way you prevent any sort of penalties involved with not complying with the statute. My name is Natalia Willette, and I am a real estate attorney here in the state of Florida from LCO Law.